consequently did not result in an infraction of South Africa or public international law, despite the extradition without due process. In the present application, it was contended on behalf of the applicant that consent may not be given to unconstitutional conduct because it would undermine the doctrine of objective constitutional invalidity. In this respect, it was eloquently argued by Mr. Perumal Saimi that no person can waive a fundamental or constitutional right. This court erred in that it did not declare the conduct of the respondents unconstitutional, and this omission by the court also has implications for the costs order made by the court in constitutional matters he submitted. In this respect, he argued there is a reasonable prospect of success on appeal. Curiously enough, there was no mention in the notice of motion of relief sought on a constitutional basis. The relief sought was to declare the arrest and transportation to South Africa to be wrongful and unlawful. Only in her replying affidavit did the applicant aver that an extradition disguised as a deportation is inconsistent with the Constitution. Despite this, the notice of motion was never amended. The relief sought in the notice of motion was directed at the alleged conduct of the South African police in Tanzania. This was the issue that this court had to decide, and not the constitutionality of the 6 respondents' conduct. In Minister of Cooperative Governance and Traditional Affairs versus De Beer and another, 2021, 3 All SA 723, Supreme Court of Appeal at paragraph 85, the Supreme Court of Appeal found that the respondents were granted relief that had never been sought and that the High Court had ranged beyond what had been sought by the respondents. Moreover, the Constitutional Court held in South African Transport and Allied Workers Union versus Garwas, 2013-1, SA 83, Constitutional Court at paragraph 108 up to 114, that if a party wishes a declaration of invalidity, it must properly and specifically place such an issue before the court. It is only when that is done that the obligation on the court in terms of section 172(1)(a) of the Constitution is activated. I therefore find that there is also no reasonable prospect of success on the court's failure to declare the 6 respondents' conduct unconstitutional. The facts of the matter simply did not pave the way for such a declarator. The question whether a person can waive a fundamental or constitutional right therefore falls away. The next question is whether the consent of the applicant was a proper consent and whether it could ever override the irregular disguised extradition. In this respect, I was referred to the stance of the Supreme Court of Appeal and the High Court of Transvaal on waiver and consent, as expressed in Spagni versus Acting DPP and others, 2023, Zaska 24, case number 455/2022, and State versus Shaba and another, 1998, 2 BCLR 220, Transvaal, respectively. It was submitted on behalf of the applicant that the Spagni case points to the fact that the consent must be in writing and that it must be unequivocal. In the Shaba case, it was held that rights enshrined in the interim constitution are inalienable rights. It is further submitted on behalf of the applicant that these decisions are in conflict with the judgment presently under scrutiny, and that this fact represents a compelling reason why the appeal should be heard. Once again, one has to revert back to the version of the respondents. It is not their version that the applicant had consented to the disguised extradition process, nor is it their version that she had actually consented to anything that was taking place at the time. It is simply their version that she wanted to return to South Africa to her children. This was the true nature of her consent, and in my view, the other cases referred to are therefore distinguishable from the present case. Insofar as the applicant contends that the Supreme Court of Appeal should be allowed to consider whether a person may or may not consent to an unlawful and unconstitutional act, I therefore respectfully disagree. In the Mohammed case referred to in my judgment, the Constitutional Court left open that question, but in the Mahala and December cases also quoted in my judgment, the then Appellate Division held that where a person voluntarily returned to South Africa, there was no infraction of South African or public international law. There is then also no violation of such persons' fundamental human rights. It was held in the Mahala case. These cases have not been overruled and they still stand. Having regard to all the submissions made on behalf of the applicant in the present application for leave, I am of the view that those submissions cannot be successful in light of the findings of fact made by this court in the application launched by the applicant. I am therefore not persuaded that another court would come to a different conclusion, or that there are other compelling reasons why the matter should proceed on appeal. The following order is therefore made. The application for leave to appeal is dismissed with costs. The court will now adjourn.
Would you guys please, as quickly as possible, pack up because our other cases must start. The file will go down to the general office after the order is typed, then you can get type judgments. Môre. Hoe dink jy? Wat is al die idee?
Laziness. Laziness.